Good afternoon. Welcome to our program today entitled Government Investigations and Controversies, Key Legal and Communication Strategies for Nonprofits to Prepare for and Manage the Crisis. My name is Jeff Tenenbaum, Chair of the Nonprofit Organizations Practice here at the Venable Law Firm, and this program is part of the monthly series that we've been doing for 6 years now on a wide variety of nonprofit legal and related topics. And this is now the second program we're doing in our brand new building in Washington, D.C. with, thankfully for those webinar participants, we have a couple hundred of you joining us from across the country today with a live video stream as well. So we're very excited about that. And as many of you know, all of these programs are recorded and posted the day after the program on our nonprofit YouTube channel. A link to that recording will be sent to all registrants for today's program tomorrow. A few housekeeping tips before we get into the substance of today's program. First of all, for those of you from the trade community, these programs are eligible for CAE Continuing Association Education Credit, a Certified Association Executive Continuing Education Credit. Preview of our upcoming programs. Next month, May 18th, for those of you that operate internationally, like increasingly many nonprofits do, our program is entitled Moving Money Overseas and Back, What Every Nonprofit Operating Internationally Needs to Know. Very excited about that program. It's an area that we do an increasing amount of work, and there's a really interesting and complex array of issues that we're going to be dealing with next month. And then on June 13th, our program is entitled An Independent Contractor, an Employee, and Their Attorney Walk Into a Bar. Why this is no joke for a nonprofit. This is one of those topics, kind of the issue of independent contractors versus employees, that's not necessarily a new and hot topic, but it's an old topic that continues to have important ramifications for every nonprofit organization. Always seems to draw a good crowd, and looking forward to that program in June. And we will have more programs to announce soon. For handout material, first off, those of you in the room have a printed booklet that has a copy of today's PowerPoint slides along with full bios for our speakers and some ancillary related articles as handout materials. Those of you in the webinar received a link as part of your confirmation email that had a link to the PowerPoint slides. And like I said earlier, all of you will receive an email tomorrow that contains all of this information electronically along with a recording of today's program. In terms of questions today, we encourage you to ask questions throughout the program. For those of you in the room, raise your hand and wait for someone to come to you with the handheld microphone so that everyone on the webinar can hear you. And for those of you on the webinar, please pose your questions to me using the chat feature on the webinar software, and I will pose them to our speakers at the appropriate time. Now, let's talk about our speakers themselves and the topic itself. First off, this is a topic and an area in which Venable does extensive work for all different types of nonprofits and has for years and years, and has frankly had a great degree of success, which is important. You want someone representing you in connection with an investigation that's not only knows what they're doing, but is going to help you get a good outcome. And what I'm expecting and hoping from today's program is that we're going to be able to share a lot of those tips with you. Not only things you want to do and not do when you're an organization gets hit with notice of some form of a federal or state governmental investigation, but also what are the things you can do preemptively, proactively, prophylactically to help better prepare your organization for that potential investigation. You're going to learn a lot about that here today. And I'm really looking forward to the program. Our speakers, first, in the middle we have Eric Jones. Eric is a partner in Venable's D.C. office where he helps lead the firm's congressional investigations practice and works very closely with our state attorneys general practice and our privacy and data security practice. He has very significant investigatory and policy experience in state and federal government. Prior to joining Venable, he served as an assistant attorney general and director of the Policy Bureau for the Illinois Office of Attorney General Lisa Madigan. Prior to that, he was Deputy General Counsel and Chief Investigative Counsel to the U.S. Senate Committee on Commerce under Senator Jay Rockefeller. And he's led and worked on a diverse range of congressional investigations relating to frankly, a whole variety of topics. Eric is extremely well situated to speak with you here today, and I think I know you're gonna learn a lot from his comments and insights. To Eric's left is Alex McGarris. Alex is a counsel here at Venable, based in our New York office, but spends a lot of time here in D.C., and has been one of our go-to folks when it comes to all sorts of particularly federal investigations from a wide variety of federal agencies, including the Consumer Financial Protection Bureau, the Federal Trade Commission, also state attorneys general, the U.S. Postal Service, and congressional investigations. I've worked closely with Alex in connection with a number of investigations of our nonprofit clients over the years. She's fantastic, has a ton of practical insights that I know you're going to benefit from here today. And last but not least, as we try to do often for most of our programs, we try to bring in folks from outside of Venable so you can get different perspectives. And as any of you who have been through a governmental investigation know, the legal issues are certainly very important, but they're not the only thing that's important. And the public relations and crisis communication side of the work that has to be done is critically important to a successful outcome and a successful and a survival rate for your nonprofit organization. And it's hard to find a person better equipped to help speak to those issues than Tracy Schmaler. Tracy is a managing director at Kivit and leads their crisis communications, litigations, and issues management practice. Prior to joining Kivit, Tracy managed the Office of Public Affairs at the U.S. Department of Justice and served as a senior advisor to Attorney General Eric Holder. While she was there, she was responsible for the department's media strategy on high-profile law enforcement policy and legislative issues, congressional investigations, and other areas. Prior to that, she oversaw global public affairs for Yahoo, where she advised the CEO and executive leadership team on communication strategy and related issues. And she also worked for the Senate Judiciary Committee, where she served as a communications director for the committee and its chairman, Senator Patrick Leahy. Tracy is extremely well-respected in the field, and I'm very excited for the contribution she's going to make here today. So without any further ado, I'm going to turn it over to Eric to get us started. Eric.
Thanks, Jeff. Appreciate that. So before we jump in, I just wanted to ask you all quickly, how many of you have dealt with an investigation just to get an understanding of where the experience lies? Okay, a handful. And I know, Eric, I know you have, but you're not raising your hand. Eric's a colleague of ours here, and I know he's done a lot of work on this. That's helpful. Thank you. And so I want to also mention that as we're going through, we have slides that we're going to walk you through, but on our end, we view this as a conversation. You'll see us asking each other questions as we're moving forward. And if any of you have a question at any point while we're discussing any topic, please jump in and ask a question, because we think these are more productive when we view it as a two-way conversation rather than just a presentation. And then finally, I just want to say it's really great that Tracy was able to join us for this. We appreciate it, because having served both on the private sector side and the public sector side, I can tell you that a communication strategy is incredibly important, and it's very critical that you have the legal and the communication side all working hand in hand. That's how you effectively respond to these things. So let me walk you through quickly the topics we're going to cover today. In general terms, we're going to walk you through what an investigation looks like, how it'll start, how you'll respond to it. And the most important question, which will be the first one, is an overview of the government agencies with enforcement and investigative authority relevant to nonprofit organizations. As we're going to discuss, the entity that is asking questions is going to have an impact on how you respond, and it's important not to forget that. And I've seen that mistake made in the past, and so it's very, very important to think about whether or not it's Congress asking questions, or it's a state attorney general, or it's the Department of Justice, or it's the FTC. We'll walk you through the anatomy of a government investigation, how the CID or the subpoena would come in, how you respond to it. And I should say, I threw out an acronym. CID, which I'll be using over and over again, is a civil investigative demand. If I say CID, it means the same as a subpoena. The strategies for navigating the process and mitigating fallout, which we'll spend a lot of time on. And then Tracy will cover why you should have a crisis communications plan and the guiding principles, which are the do's and don'ts of how to communicate. And we'll talk about the principles of issue management and crisis response. And then finally, we'll switch gears a bit and also talk about investments in compliance to avoid investigations and how to learn from a crisis, because if there's anything more important than effectively responding to an investigation, it's figuring out a way to ensure the investigation never happens in the first place. So without further ado, let me jump right in. We started with, this slide is just an overview of a few examples of recent actions by government agencies at both the federal level and the state level that targeted nonprofits. Because I think it's one thing to talk about how investigations are important, but I think we also need to show you that investigations are relevant to nonprofits. They do get caught up in investigations, and they have been a target in the past, and we would expect them to be a target in the future. This shows that the FTC has been involved, that they've gone after entities claiming to be cancer charities. You can see that there was in the New York Times, there was an article about a state-level investigation. And then, finally, I specifically wanted to include this one, the article in Science about, fact-checking Congress's fetal tissue report. I don't know if you're all familiar with this, but the Congress created a select panel to investigate Planned Parenthood, and that brought in Planned Parenthood, a number of other nonprofits and universities that were involved in fetal tissue research. And I wanted to make sure we included that because that was an area where there was not necessarily a crime that had been committed or any civil litigation that was occurring, but it ended up being an incredibly important investigation for that entity, and that can occur from time to time depending upon what Congress is focused on. And I want to turn to Tracy to see if she has anything to add just from the communications side.
Yeah, well, I think on that one, having actually worked on that one, it's an example of really how high profile an investigation can become when you start with Congress creating this separate entity to look into it, but also being very aggressive, not only in its investigation practices, but also in how it advanced its goals, if you will, through the media, and making sure that, I think we can talk more about it when we get to it later in the presentation, but how Planned Parenthood really sort of confronted that, responded to it in a way that was very successful in mitigating that investigation and how it developed.
Yeah, great point. I guess if I could summarize this slide in one sentence, it would be investigations can have a significant impact on nonprofits, and they can certainly make national news. Next slide.
One corollary point to that, too, before we move on. Not every investigation is public from the beginning. In fact, many, I might even say most, that I've been involved in don't start by being public. Some certainly do, and like Tracy just said, some are brought, for public relations and policy advantage and jockeying impact as much as anything else. But many of them start without any public disclosure. Some, like for instance, IRS audits, are not allowed to be publicized until the very end, and even then, the name of the target generally has to be redacted. And so it's something to keep in mind that many of the most successful investigations that we've helped navigate either never became public, or when they finally did become public, the way it was disclosed. I remember we had a U.S. Department of Justice Criminal Tax Division investigation of one of our clients, and in the end, when we finally settled it and resolved it, we negotiated the terms of the press release and everything else, to ensure that it was done in the most favorable way that we could get accomplished for our client, which is pretty good. And so that's another thing to keep in mind, is that dealing with the confidentiality of investigation, keeping it that way, how it does become publicized, is a critically important point.
Yeah, and I would just add, actually, that in a good number of the matters that I initially get brought into, the goal is to keep it out of the press. Having a plan and being prepared doesn't mean you proactively go out and advertise or discuss or even advance your view publicly, because that's not going to help what your ultimate goal is around the investigation. But making sure that you are prepared, and you can, we'll talk about it a little bit later, you can do a few things to sort of ensure, or at least try to minimize, any attention from the investigation.
I think, Jeff, I'm glad you raised that. That's a really great point. And we're going to actually be talking about that a little further, about what it means when you receive if the investigation starts with a letter, and then before you know it, there's a press release from the agency or an article in the New York Times or the Washington Post, or it's the latter, and what Jeff was referring to, which is a non-public investigation where you just receive a CID or a subpoena from a staff attorney working inside an agency, and how you navigate those situations, because they both bring challenges, but they're very different landscapes when one begins at the public and one begins non-public.
And sometimes, too, especially in the non-public ones, your organization may not be the the direct target of the investigation. In fact, may not be a target at all. And that's always one of the first questions we ask, is our client a target of the investigation or not? Just because they're not a target initially doesn't mean they won't become a target. So part of a successful strategy for navigating these things is to help make sure that your organization does not become a target. And you can show whatever bad actions might have happened, your organization might have been involved in them in some way, but didn't do anything wrong. And so that's the argument you sometimes want to make.
Yeah, and actually there's, I had a client that was subject to both sort of a congressional investigation and criminal investigation, and it was really more the industry practices, and so we were not the target, but we certainly made sure that we had a plan when we were asked questions. We were more of a subject matter resource, and so the reporters and the media looked at us as an expert voice, and that helped us manage and sort of control some of the coverage around this broader investigation where we weren't a target, though we were certainly part of the universe that was.
Great point. So this slide has we just included a number of agencies and committees just so you could get a sense for if there were to be an investigation that your organization had to deal with, who would it be, who would be leading it? And so at the federal level, it would likely be the Department of Justice, who has both criminal and civil authority to investigate a whole host of issues that would be relevant to nonprofits. The IRS, as Jeff already mentioned. And then finally, the Federal Trade Commission. They have been fairly active when it comes to some issues related to charities and some of the claims that are being made related to them. Additionally, at the federal level, it's important, and given my background, I always want to make sure we mention this because it can be forgotten from time to time, but as I said, congressional investigations can, even though they don't have authority to bring civil penalties or to force a settlement, Congress can have a significant impact on an organization if they decide to focus on you or your organization, or pull you into something that maybe you're not responsible for, but you're tangentially related to, and you have to get pulled into it. And we can talk about that a little bit further once we get into the sort of the details on how to respond. And then finally, I think it's important that we don't forget the relevance and the work that the state attorneys general do. They are very active, led by a few large states, but all of them get involved together. And when they come together, they will create multi-state investigations where, while a couple states will lead, but nearly every state will be part of it. Which, when they do that, they can have the same kind of impact on an organization as the FTC or the Department of Justice. And frequently, the state AGs will partner with the Federal Trade Commission or the Department of Justice and run parallel investigations. And when an organization gets caught up in that, they need to understand that. There is and we'll talk about this further, but there's a slightly different sort of play and response when you're dealing with the state AG versus the FTC or the Department of Justice. You can't treat all of them exactly the same. And so I wanted to make sure we mentioned that. And then finally, just to add that, at the state level, a number of states have laws that are related to charities specifically. I know that in Illinois, there was a charities bureau, so they also have authority over sort of maybe it's notification requirements or different regulations that they have to and a nonprofit have to comply with at the state level as well. So I wanted to make sure we mentioned that.
Yeah, just a few points to add on to that. There's been a lot of discussion in recent months and years about kind of nonprofit regulation and is the IRS going too far in trying to regulate not just tax law compliance, but governance practices and things like that? There's a very active, healthy debate going on in the nonprofit tax community about that. But what is very clear, whether you agree the IRS is overstepping its legal authority or not, is the fact that state attorneys general have definitely filled that void more and more in recent years. And they do, in most states, they have the division that regulates nonprofits. It's called a charities bureau, and they do tend to focus primarily on 501c3 charities or sham 501c3 charities. But they have broad authority over all nonprofit corporations, including trade and professional associations and advocacy groups and everything else. And some of the states have become more active than ever before. I mean, New York, arguably the most aggressive and active these days in pursuing enforcement in this area. So it's something you have to pay attention to. Also, I'd be remiss, especially with Alex on the panel, who does a huge amount of work with the Consumer Financial Protection Bureau. That's an agency maybe whose future may be in doubt under the current administration, but who has been extremely aggressive in going after nonprofits and for-profits and others in the consumer finance space. And then the last, we probably should have included an icon here for federal inspector general's offices. So anytime you get federal money, grants, cooperative agreements, contracts, and we have many, many clients who do, enforcement can come from a compliance office within that agency, but it can also come from the inspector general's office, which is kind of an independent agency that reports to Congress, and there's an IG office for every federal agency, or most federal agencies, and they have become increasingly active in investigating use and misuse of federal funds, and it's become, frankly, increasingly occupies our time quite a bit in dealing with the compliance issues there. So if you get any federal money at all, you're of course subject to all the compliance requirements that go along with it, but you're also subject to potential investigation and enforcement from the IG.
I'm really glad you mentioned that. That was an oversight on our part. We should include that, and I think we'll make sure to add that moving forward. But inspectors general play an incredibly important role, and I even saw that in my own career, where you wouldn't think it, but even the National Science Foundation had a very active, aggressive IG's office who would bring investigations. So I think it's really important that we not forget them. Thanks for bringing that up.
We had one of these programs a few months ago, two of them. You might have been here for them. We had a woman from the USAID Inspector General's office, who's probably one of the most aggressive IGs. I have great respect for her. We might have gone head-to-head on a few issues on those panels, but she's fantastic, but takes her job very seriously, and she is very aggressive in going after recipients of federal funds from USAID.
Yeah, that's a really great point. And I'm now going to turn it over to Alex, who's going to walk you through the launch of an investigation.
Sure. So clients of mine that receive CIDs or subpoenas, the first question they ask is, why us? How did this start? What is the genesis typically of an investigation by a government enforcement agency? And while there's obviously no one size fits all, certainly all government agencies have limited resources, and as a result, they also have a lot of potential targets. And as a result, when they do make the decision to pursue an investigation of an organization, they're pretty deliberate and careful up front when making those types of decisions, and a lot of competing factors and priorities in a given agency, office, or committee when deciding how to allocate those precious resources. On one side of the spectrum, you may have kind of a reliable, specific evidence that an organization, engaged in illegal conduct where there's donor consumer harm. That's a clear area where an agency would potentially pursue that organization. On the other side of the spectrum, you can have political pressure to go after a specific industry or set of practices, and the selection of the target can be almost arbitrary. Typically, you'll go after like the biggest player and try to find something there to see if there can be action brought. But the majority of investigations that we see kind of are born somewhere in the middle, and various factors contribute to an agency deciding whether or not to take or to consider taking action. First, I think, and foremost, at least in my experience, and I'll be interested to hear what Eric thinks, complaints from consumers, donors, or the potential, the beneficiaries of potential organizations' work. Especially you think of agencies like a state attorney general and a federal trade commission. A lot of their work is collecting these complaints from the population on organizations and companies, and they spend a lot of resources mining that information, but also, especially with the AGs, kind of serving as liaisons between the person making the complaint and the organization being complained about. So organizations that are not taking complaints, donor complaints seriously, are always at a higher risk of being the target or subject of an investigation. Another area that organizations have less control over is just the political and economic landscape in which you operate. I think we're in DC. You all probably are DC-based organizations or have a DC presence. Certainly not naive to this, that what's happening in the political environment, what's happening on the news, is very much going to potentially impact the priorities of political beasts like an AG's office, but also organizations like the Federal Trade Commission. And so you have to be mindful of that. You can get caught up in the crossfire there. And then third, and this of course is where Tracy's expertise comes into play, media attention to an issue oftentimes directly will result in a CID. I cannot tell you how many times I've dealt with clients where the New York Times will cover a practice, especially in the consumer finance area in the last few years, which has been kind of a hot area, and the next day they'll receive a CID from either the CFPB or a state attorney general. Especially for political beasts like an AG, having their local paper cover an issue that they're not on top of looks really bad. So you want to manage that, not only to be reactive to it, but be proactive. And then, of course, whistleblower complaints, someone from inside the organization that has access to very specific information that the agency can rely on. That's usually the easiest way for them to make the case to their supervisors to launch an investigation.
Yeah, I cannot stress how important that is, how many times that's happened. And so what that means for you preemptively is that if you know there's some big media story about to break, you need to not only be prepared and work with people like Tracy to help prepare you for it, but you also have to be prepared for that government investigation. That means all the other kind of stuff that we're going to be talking about here, you really need to think about. And sometimes it can have real consequences. We saw, I think, virtually almost the day after David Fahrenholtz started writing his Washington Post stories about the Trump Foundation, the New York Attorney General's office opened an investigation of the Trump Foundation, and several months later, the foundation was shut down. Obviously, a lot of politics went into that decision as well. But it just goes to show you
all the factors rolled up into
the relation between media coverage and governmental investigation, investigative actions, and the ultimate effect it can have on an organization.
Yeah, I actually think this is a great slide because it's almost your early alert system. So to the extent somewhere in your organization there are touch points that when you look back on it, you will say, oh, we could have seen this coming.
Yeah, and just to add a couple points to this. One, I think Alex really nailed this about what this looks like from the government side, having been on the inside and seen how this will play out. First, when there's an article that appears and that makes national news or even local news, what ends up happening, it's not just that the Attorney General or maybe the FTC or whoever, but especially those who are elected officials and have to respond to these things, they'll actually get a call from a local producer for a television station or a local reporter and say, hey, I read about this in the New York Times. What are you doing about it? And then that will cascade through the office, and that question will be asked over and over again until it makes it all the way up to the Attorney General. And then they'll say, well, what are we doing about this? And then by the end of the day or the next day, they'll say, I think we're issuing a CID on this, because they're going to feel a lot of pressure to respond to it. And it does not take a lot of work for an office to open up an investigation in response to something.
And that's a good segue to our next slide. If you want to advance it there.
Sure.
In that situation, it's almost certainly going to be a public investigation because they want it to be public, and that's part of the reason for doing so. But Alex,
sure.
why don't you take it from there?
And so we're going to spend a lot of time today walking through, as Eric previewed, kind of the anatomy of an investigation. What we have is kind of your typical, albeit generic investigation, which is what we'll cover today. And by typical, kind of defining it based on what it's not. There's just kind of two paths by which an enforcement action can unfold. The first is through public means where the entity is informed of the investigation, so is the public, and they're invited to participate. And there are other ways where it's non-public, where a CID is issued, typically confidential. Typically, the agency is bound by confidentiality rules, so it cannot disclose the fact that it's investigating the organization. Typically, under most rules that govern these investigations, the target of the investigation can disclose should it want to. And we can go into, when we get to Tracy's piece, as to the pros and cons of disclosing that up front. And in some cases, you have no choice but to make certain disclosures to certain stakeholders and counterparties. But in most cases, when you're dealing with like a congressional investigation, it's going to be public. I mean, there's a reason they're initiating the investigation. They want to get some political points for it, and they're typically holding public hearings, and the information is public. The investigations that I typically deal with, FTC, CFPB, state AGs, the CIDs are issued and they're not public until there is a public resolution, and we'll get into what those potential options look like in terms of resolution. But again, as we mentioned in the front, the goal is to keep it not public, to hopefully resolve it without an enforcement action, and even if there's an enforcement action, to see if there's a way to complete that without it being public, which is increasingly difficult.
And to jump in here, and Eric knows this because he was on the Hill as well, there's sort of two forms of press releases that come off of out of Congress. One is an actual press release, and one is a letter from Congress. And so, I mean, this is certainly usually their way to start memorializing their action here. And, you know, most letters, when I was at DOJ or when I was at Yahoo or now for clients, most letters that come from Congress are usually the beginning of the public part of this process, because that is where they're going to start engaging, especially when we're dealing with consumer complaints or issues that might be affecting in a harmful way the public.
And Tracy, talk us through a little bit about why. Sure. Yeah, go ahead. Oh.
All of this comes to why you need a communications plan. So there's sort of two main reasons. One, we've talked about being prepared. But two is it's a different type of communication. So, you know, most organizations have some version of an in-house communication shop, but that is mostly focused on the mission. It might be focused on marketing or raising funds, those sorts of things. But when you're dealing with an investigation or even a preliminary investigation that might turn into litigation, you know, it's important to understand that it's a different process. And so these tracks are sometimes at tension. You know, there are a lot of lawyers. None of those up here probably would tell you to just go hide in a hole and not say anything. But usually you have different audiences that you are trying to cater to or reach. And in a regulatory matter, your first and foremost audience is going to be who is looking at you. You want to minimize or mitigate whatever may come out of this process. And so you want to make sure whatever you're saying, you are saying with that in mind, right? But you also have to remember that if it does get public or becomes public in some way, you have other audiences that you have to take care of. Sometimes you're going to be required, as Alex said, but sometimes you're going to have a responsibility to employees, to your board or executive leaders, to your consumers or members. And so it's important to make sure that you have factored in what you need to be saying to them that coordinates with the investigation and what's going on sort of more internally. And that is why it's important to make sure that you've thought through what you need to be saying. And in a lot of cases, as you can imagine, it's taking the step of being responsible. You have received this information or this request. You are looking into it. If there were actions that were clearly wrong, then it might be an internal investigation. But there are ways that you can position yourself that show you as a responsible and cooperative actor in these cases. And more often than not, it's really important to make sure that the audiences, all of them, understand that about your response.
And Tracy, before you move on,
Sure.
and I'm sure you've had tons of experiences like this, through many of the situations that I've been through, sometimes it's really difficult judgment calls about what you disclose publicly and when, and of course how is critically important too. I was just recently involved in a matter for a client where there was a local news story in one city in which they operate, which led to obviously the organization being aware of the incident. Local police did an investigation, ended up closing the investigation pretty quickly, finding that there was no wrongdoing on the part of our client. But then they had the tough decision of, do we make all of our, and you know, in this case, the people that they serve, aware of what happened or not? There was no legal obligation to do so. But you know, from a public relations perspective, you know, if for instance that later gets more broadly disclosed and this organization failed to do so, that could be very harmful. At the same time, they may be opening a Pandora's box and making something out of nothing, and there really was no wrongdoing on the part, for the most part, on the part of our client.
Right, and this is where it becomes more of an art than a science, because you have to sort of make some of these judgments. Now, to the extent you want to make sure that the members or, you know, your supporters or employees understand that while there was maybe some question of wrongdoing, you want to ensure that whatever is publicly out there, you have closed that chapter, right? You have put sort of the conclusion on that, which was, to your point, Jeff, there was nothing there. And while you might take another hit of having that regurgitated in the media, you will at least have the conclusion, so if something happens. Now, it doesn't always have to be going to the media. You could, if it was something of a local story, then you want to kind of minimize it, right? But you want certain audiences to know how it concluded and that you were a good actor. So that could be an employee email or something along those lines.
And what they actually ended up deciding to do is not to put out any press release or anything, but to send a letter or an email, I forget the method of communication, to all of the people that they had served that were potentially affected by this, to let them know. And I think it was the right call, from many different perspectives. And it, like you said, it will protect them down the road.
Right.
Someone saying, "Oh, you were trying to cover something up." You don't want, the old cover-up being worse than the crime to ever be the case.
And I have that. I'm using that quote later on in the presentation.
Sorry about that.
The one thing I'll add is why a communications plan, because the government agency has one. I mean, I've worked, again, with the CFPB a lot, and their external affairs department has gotten a lot of press because they are the most powerful office at the CFPB. They have a press strategy for everything they do, and they've gotten a lot of flack for issuing press releases that almost contradict what the announcement is, right? You're mutually settling, not admitting guilt, but the press release screams like there was admission of wrongdoing. And so if you don't have a plan, you're behind, because they absolutely do.
John, you had a question?
Yes. You're addressing crises that could be caused by a formal governmental action or something that's in the mainstream media. We've seen a lot, especially from high-ranking government officials, maybe taking an organization's name, early morning tweet, if it's negative. How do you even plan or deal for that?
You mean something that would just sort of hit your brand as opposed to it being a full-on CID or subpoena? And that is where you need to, and we talked about, I think, in the beginning, or sort of having the right folks from your organization involved. So to the extent I will say almost every single one of my clients come January 21st was asking for a plan for when the president put them in a tweet. And this is where proportionality comes in. This is where content is king, and you have to understand, what is it? In some cases, it's going to be about monitoring, because you don't necessarily want to start a Twitter war with someone who has 20 million followers. So you want to make sure at that point you figure out, okay, what is it? How damaging is it? Who are the people that we really need to reach with our response, whether it's correcting an inaccuracy or doing some outreach to the administration or other regulatory agencies to get ahead of whatever may be the consequence of that tweet. But it's really important in that case to make sure that you've sort of brought together, and we get in this, let me see if I can push ahead. Bring together the people who are critical in that situation, right? You're certainly going to want lawyers in the room so that they can help you navigate where those goalposts are. You're certainly going to want communications folks. Now, again, this might get a little bit outside of the lane of your communications office. They might be sort of used to marketing or consumer communications more than this, but certainly making sure that you protect your mission, your brand, your value. Short answer is, in some cases, it's going to be a public response. In some cases, it's going to be a more targeted response to your audiences. And in some cases, you're just going to sit back and monitor and see what the fallout is before reacting too quickly. Which leads us to sort of general do's and don'ts on responding. And here we're talking more in sort of a regulatory or potential damaging investigative landscape. But you are, as you all know and as you have heard, there are going to be some real restrictions on you in the beginning. You might not know if you're a target, sort of what Jeff was saying earlier. You're asking these questions to your agency. So there's not a lot you can do. You can't come out with a full-throated defense or refutation, because you just don't know. You're still gathering all the information. So making sure that you, with media and others, set those expectations. You will share information when you have it. If it's an internal communication, acknowledging that something is going on. If it's penetrated the media, those sorts of things really help position you as a responsible actor and one who is in control. And that's really important at the outset. Clear lines of communication and decision making. This goes to what we were just talking about. Who are the people in your organization who need to be part of the decision making, right? You're going to have your leadership, you're going to have your legal team, internal or external, you're going to have your communications folks. If you have membership folks who, the person who's responsible for making sure your members are aware of what's going on, donors, supporters, boards, you're going to want to make sure you identify that team really early and get them together and understand everyone understands their roles, their responsibilities, and that also helps create a process. So when when it starts to pick up a little bit, you have already set that in motion, and everyone understands what they need to be doing. Simple and direct. Keep everything as simple and direct as possible. You may have a really valuable mission statement. You may be doing all sorts of good, but trying to shove that into a statement about a response to something that has nothing to do with that really muddles the message, and it's distracting. And people really sort of get the sense of you're trying to dodge a little. Here's one with the presidential tweet scenario. Disagree when warranted. There are many ways that you can get out there and correct facts or correct accusations. Now, it gets a little bit, it can be a little bit more sensitive when you're if you are under investigation or you're on the path to being under investigation. So that might not be something you do publicly, but you get with the team and make sure that if there is inaccurate information that you are being accused of, that is very quickly corrected. To Alex's point, I have really, even IGs, I've been on the other side of IG investigations. I've been on the other side of congressional investigations. State AGs are some of the most aggressive offices I have seen from a communication standpoint. And it's not just press releases. They talk to reporters, they talk to people in the community, they background, people know before things become public. And so it's really important to make sure that you know the information that is going out so that you can be prepared if something does get out that you don't put out. And finally, third parties. These are folks who can sort of burnish your image, burnish your value, speak to sort of what the positive is for you and the situation. And if it's a bad actor in your organization, then you can sort of try to use other folks to really sort of marginalize an individual from the organization so that the brand and the core of the organization doesn't actually get damaged through this process.
Yeah, great points. First off, two kind of examples that I think are illustrative that go to these points. One is we've had a client that's been under 2 different federal investigations now for several years, going on for quite a long time, but all of it non-public. Until recently, one of the 2 agencies decided to issue subpoenas to kind of the major companies in this industry that are the major financial supporters of this organization to try to get a sense as to what sort of transactions were going on there. And so while it's not a public disclosure, now the key stakeholders and frankly the key funders of the nonprofit organization are aware that there's something going on. So now the communication strategy becomes a lot more difficult and complicated. And what sort of strategy you approach, they definitely need your help, Tracy, for sure. And another example, there was an example where there was Eric talked earlier, some of the congressional investigations in recent years, and probably all the time, focus not only on a particular organization or company, but on an industry or industry practices that they perceive to be abusive or bad actors or whatnot. And in terms of kind of voluntary disclosures and whatnot, I remember a case of one of the CEO, one of the lead players in an industry that was under investigation by a couple committees of Congress, decided that he wanted to really go out there and hold himself out as a good guy on a white hat in the industry and doing everything right, and volunteered to go before one of the key congressional committees and gave testimony. Ended up getting completely grilled by the committee. I think had some very bad advice going in, and then ended up getting investigated, not only by another congressional committee, but by 1 or 2 federal agencies as well. So you got to sometimes be very careful before you engage in too much voluntary disclosure.
I want to add one point to that. Just from experience I had while in government, we were involved in investigating a number of entities. Their association decided to get involved as well, And I don't think there was communication happening between the lawyers and those involved on the communication strategy, because the strategy that was employed backfired because it forced the entity investigating, the government agency, into a position to go more aggressive than it actually intended, because some of the statements that were made were questioning the purpose of the investigation, questioning the authority of the investigation, and it forced the agency or the government to sort of ratchet it up a bit. And so I think I'm providing that to say that a communication strategy is incredibly important, but it's also just as important to make sure that those who are engaged in communications are also discussing with the lawyers about how we'd want all these things to play out.
That's a great point. Well, now we'll hit the don'ts. Yes. So, and you'll, as you go through this list, you'll see, I mean, these really sort of correspond a little bit. Don't hide, even if you can't say anything. There really is some value in making sure that you are at least being responsive. To Eric's point, you know, making sure everyone who needs to be involved is involved. There should be somebody on that team who is the point person for media and external communications. And that is how you, in that core team, figure out what that strategy is, but you also know what's coming in. So you know if there's going to be a front page story in the New York Times or in the Daily Ledger about what's going on in one of the state offices. It's really important to be able to manage it knowing what's happening out there. Don't speculate. This is really, really important. You know, to the extent there's always an urge to sort of get out and try to either minimize or dodge or sort of distract a little bit. This is where it really is important to just either, if you don't have anything to say, do your best at saying we're aware of it, we're looking into it, but speculation, I'm not going to accuse anyone of wanting to lie, but speculation can really be a dangerous path to go down. You'll see the others here. Coordination is key. This is where you know you can get a pretty good roadmap of where investigators are going to go by the types of calls you're getting from either media or members or outside stakeholders. Because as we've talked about, in a lot of these situations, they are the drivers, and then the regulators or investigators react to it, especially when you get to the level of Congress or state AGs, because that's where they feel pressure. Don't be cold. The perfect example of this is probably how United handled the passenger being dragged off the airplane. They didn't apologize. They didn't acknowledge what a bloodied passenger being dragged through the aisles and off the tarmac until much later, and the consequences clearly were devastating. Don't fall behind. This is where American Airlines learned from United's example, and very quickly when they had that video go viral of their flight attendant sort of confronting a passenger, they got out front. They apologized. They said it was not within their values or didn't conform with their values, and they put that flight attendant on suspension. So taking control, and even though they were still going to investigate, those are two very good examples of how you can sort of misstep early.
We have a question in the back.
Yes, hi. Oh, sorry. So I have a question about speaking on background versus speaking off the record. Mm-hmm. If some information has been reported on your organization that's not accurate, and you want to get the correct information out there, the first part of my question is, how do you convince your leadership that it would be worth considering possibly speaking on background to get the right information out there, or speaking off the record if you have a good relationship with the news media and you can trust them? So what advice would you give if you're in that situation and you want to advise the leadership that we should consider either option?
That's a great question, because there is always a sort of tendency to be cautious, I think, particularly as you're in the middle of these things. And it comes down to that conversation about what is the damage, right? So this damage is happening to the brand, the identity, and you know, potentially funds, donations, whatnot coming in. And so, you know, understanding that that's happening regardless of whether this information is accurate or inaccurate. But also, one very compelling way is to consult with the lawyers, of course, to make sure, but if it's inaccurate, it's going to come out sooner or later. And what is the way to do that? So, I always caution about trusting the media. I'm a former reporter, but, background and off the record are very important tactics for them. It's how they gather information and inform their reporting writ large. So, I do always find myself in these situations really trying to pull as many people from that core team together to the executive, or if it's the general counsel resisting the background or off the record conversation, to really sort of lay out, here are the consequences, right? This is happening right now. This could potentially escalate with this inaccurate information. Now, if there is still that resistance, then I think this is also an opportunity to sort of try to use third parties, or try to use some communications or other sort of pieces, communication pieces in the process to correct that information, right? If the lawyers go back to the entity to say this is inaccurate, then you have something you can point to.
And a lot of times it's a hybrid. It's a combination. I've given many interviews to the media on behalf of clients over the years, and sometimes just as kind of an industry expert in the nonprofit sector. But when doing on behalf of clients, a lot of times what I'll find is I'm giving a lot of information on background to clear the air, make sure that the reporter has accurate facts, understands all the details. That has been invaluable. And like Tracy said, you can often tell from the initial questions of a reporter where he or she is going with something. And it's been very gratifying for me and for my clients to sometimes see that story really change course after having those background discussions. But sometimes it's also important to go on the record with certain comments. So everything you said on background, you may not want to be on the record, but you may give one or two sentence quote on the record that's maybe not going into as much of the substance, but making the point that you want to make. And sometimes you do it at the same time, sometimes you might do it later, sometimes, like Tracy said, you want to have a third party give that on the record positive comment about your organization. It really depends. It's very fluid. It depends on the facts, on the timing, but I think on the record comments are equally as important as the off the record comments, and I'm glad that you raised the question.
One thing we haven't talked about yet is how to do this without antagonizing the agency that's investigating you. I mean, especially wrong about either when the investigation is still open, or even if it's closed, we're talking about a settlement or announcement of a lawsuit. There's an ongoing relationship. Typically, think about the IRS. You have an ongoing, forever relationship with the IRS. How do you communicate to the public without antagonizing the investigation team?
Yeah, and that was sort of what I was going to follow up with Jeff's comments, because you do want to make sure that if it is a piece of inaccurate information and the regulatory body has it and is operating under that assumption, they don't read it in the press for the first time. Now, you can coordinate that, but that goes back to making sure that whatever you're communicating, whether it's to the media or your members or your board, that it is in coordination with how you are responding to this process. Because remember, at the end of the day, the outcome of this process is what is critical. You do not want this to escalate. You do not want it to turn into investigation. You do not want it to turn into litigation. And so it's really important to make sure that those two things are coordinated. Now, when it gets antagonistic, then you sort of reassess some of the tactics. And to Jeff's point, you might not want to be that source, but that is also something that you would want to think through in your communication strategy.
One last comment, then we have to move this thing along, because I'm as much the cause for the delay as anyone else. But for those charities in the room and on the webinar today, you're very well aware that these kind of charity rating services and watchdog groups are another element, and we covered this in a program that Eric, we were on a few months ago, and that's another critical component of this. I can't tell you how many times that charity clients of ours have gotten, on kind of the negative watchdog list or ratings or warnings simply based on media coverage alone. In fact, seems like 95% of the time that is what causes that, and we're generally able to successfully resolve it after some really tense back and forth with the rating organization. But it's another thing you have to really keep in mind. That can do tremendous damage to your ability to attract charitable donations, grants from foundations, from governments, et cetera.
Absolutely. All right, so I'm going to turn this back over to Eric and Alex on investigations.
Great. Okay, so now we get to the the non-fun part, I guess I'd say. This is what I specialize in, so I don't want to sound excited talking about it because I know how difficult it is for on your end to deal with it. So we're very, we always think about that. But this is the part where, okay, the subpoena arrived or the letter from an agency arrived. Now what? What do we do? And the first step, and maybe this goes without saying, but I think it's just important to share, is gather as much information as you possibly can about why it's occurring, what is occurring, and who is involved as soon as you can. Because you're going to likely be, even if it's public or non-public, when you get that CID or you get that letter, you're going to be behind already. Unless sometimes you can anticipate that it's coming and you've really done everything you can to prepare for it, and when it arrives you say, oh, here it is, we knew it was going to happen and we're ready. But it's impossible to do that at all times, and so there's a good chance that you receive something and it might be out of the blue and it absolutely ruins your day. And once you've gotten over that, you can start thinking about how to respond to it. The first thing to do is evaluate the source of requests. And that's what we've been going through earlier, which is, who is it that sent me this information? Is this Congress? Is this a federal agency? Is this a state agency? And part of that process is evaluating it as well. A very basic question is, do they have authority over me, and what enforcement authority are they using? Because that always isn't as clear as one would think. Agencies and Congress are prone to trying to expand their authority and be very aggressive with it, and it's very important to ask yourself that question at an initial step. Another question to ask yourself is, what's the scope of this? Is this, and we've touched upon this already, is this targeted at our organization broadly? It touches upon our very mission, or are we more tangential to it? Those kinds of questions will help you understand what kind of level of resources you need to commit to it, and whether or not you need to bring in outside counsel, which I'm going to talk about in just a moment. Before I get to that, I want to just also add, you need to determine the legal posture you're in. So we've been talking a lot about subpoenas and CIDs, but not all requests are compulsory. There are voluntary requests that come in from Congress, where it's just a letter. It doesn't say you have to give us this. It just asks you a bunch of questions, and maybe they do it publicly. And they think that, well, if we do this publicly, they'll probably want to answer the questions. State AGs do the same thing. I've seen the New York AG do this. He's been very successful. Instead of issuing a CID, they just ask a bunch of questions and see what happens. And so it's important to understand which, are you in a compulsory process or are you in a voluntary process, because there are a lot of ways to respond to that. And all these questions, this is the moment when you need to determine, based upon all these questions you're asking yourself, whether or not you have the capability as an organization to handle it internally, or whether or not you need to bring in outside counsel. And that's getting to the next step, which is engaging with staff to limit the burden and understand the basis for the investigation. And I cannot stress this enough. This is typically where outside counsel would jump in at the first step, which is they would start being the interface between an organization, a nonprofit, and the government agency. And I can't stress enough how important it is to not sit on this. When you get a CID or some request, you're not going to want to think about it, and you're going to go to something else and say, oh, we'll get to that tomorrow. But it's really critical to get in with and call the staff sooner than later, because typically there's going to be some kind of deadline in the letter or in the CID, and typically that deadline, and maybe you all know this, but I sort of know it from my own background, that deadline is made up out of thin air. So it's literally, it'll say, you have to give us everything you've ever created, and you have to search all of your email, and we'll want it in 2 weeks. And you're going to say, that is the craziest thing I've ever heard. How are we possibly going to respond to this? And what a lawyer will tell you is, they just made that date up, and you've got to start. But and you can push that date back because it isn't reasonable. But they do it because they have to set a date, otherwise a deadline. Otherwise, nothing would ever get done. But they also are expecting that phone call. And the sooner that phone call happens, and the sooner you, which gets into our next point, but the sooner you're able to start negotiating on the timeline and the scope, the better off you're going to be. You don't want to be in a position of calling an assistant attorney general or a congressional investigator or somebody at the CFPB or the FTC the day before a deadline. because that puts the staff in a difficult position. They have their own issues they have to deal with supervisors, and so you want to give them the space to negotiate with you on being able to extend it, and typically you can do that. I mean, I once said, on my side, I deal with congressional investigations in states and across the board, but I had a congressional investigator call me, and they wanted all this information from a client within like a week, and I just, he kept pushing on us, and I finally just said, look, I know you want all this. I can't make that happen for you just because you asked for it. Like, if you told me you didn't want the sun to rise tomorrow, I couldn't do anything about that either. And finally, once he got that, he started to back away. But it's just important to do that sooner than later. And then the last point is, and this ties into the prior two, is get a handle on what your documents are and where the information is and who has access to it and who internally is going to be part of the process of helping the attorney find the information. Because it's really important when you want somebody from either your GC's office or outside counsel is working with employees internally to obtain information, that they're able to go through that process. And part of that is putting a hold down, which your general counsel's office would issue a litigation hold so that everyone knows not to go around deleting all their materials. That's a bad thing. Don't ever do that. But then also to just understand what it's going to take to put this together and get timelines so that when your attorneys are talking to the staff involved, they have all the information they need to be able to make the case so we can get under a reasonable time frame rather than have to deal with everything quickly.
3 really quick corollary points here. First, on the voluntary versus compulsory, sometimes we've been in situations where the request is voluntary, but it's actually preferable for us to ask for a compulsory request because we feel like if we voluntarily comply and that later comes out, our supporters, our funders, our members may get really angry at us, whereas if it's compulsory, even if it's not public, we can use that as protection, and that happens more than you might think. Secondly, and both of these second and third points we're going to talk about further, but I wanted to stress it here. Right from the get-go, this information gathering, it's absolutely critical that you involve legal counsel. In-house legal counsel if you have it, but oftentimes for attorney-client privilege purposes, outside counsel as well, because you want the entire process from the start to be able to have the protection of the attorney-client privilege. And if you aren't using legal counsel, especially outside legal counsel where the argument is much stronger, then whatever might come out through that initial fact-gathering process may be subject to compulsory disclosure to the investigators later, either that agency or even others down the road. Whereas if you do it all under the auspices of the attorney-client privilege, it can generally all be protected. So that's absolutely critical. And then the last thing is, and again, it's important from the get-go, that whoever you're having be the primary interface, and oftentimes it is outside counsel with the investigator, building a strong rapport with the investigator. It does not mean doing everything the investigator wants, not by any stretch. But it does mean building a rapport where there's trust, where there's respect, where there's, you're building some form of connection. I can't tell you how many cases I've been able to help successfully resolve for our clients because I was able to build trust with that primary person and get them to say, no, I need you to go push back on your guys to get them to agree to this, and I'll do the same on my side. But when you build that kind of trust and relationship with an investigator, it can be so valuable in the end in so many aspects of the resolution.
I just want to add a quick point to that. One, you're absolutely right on building trust. That is critical. But the point I wanted to add to is I have actually seen investigators start to try to do an investigation of the response to the investigation. I mean, that actually happens. And so the idea that you need to have that information protected by the attorney-client privilege is critical, because if you have not done that, and then the investigators going down the path of trying to find out your email traffic where you were responding to the subpoena internally, that's a bad path to be going down, and you can prevent it just by having it all under the attorney-client privilege.
So we're going to unpack some of the different steps that Eric just walked us through. We broke down kind of the investigation into 6 steps. We certainly don't have enough time today to cover each of them in great detail. I could talk about this for literally hours, but we'll just kind of relay some tips and pointers that we've picked up over the years. And starting with step 1, I can't stress enough, after you're done panicking that you've received this, look at it very carefully, read every single word, because it's going to reveal a lot about whether or not you're the target of the investigation or you're just being sought information that you might have about another party. How far along the investigation is depends on the types of questions you're getting. You'll know, are they starting from scratch, or do they already have a case and they're just looking to plug certain holes? The purpose of the investigation. So all CIDs typically are governed by the respective agency's rules of practice. They're required to include certain disclosures to the recipient and instructions about how to comply with the CID. Both of those are very important, not only for the compliance piece, but it allows you to kind of at least try to read the tea leaves as to what this is and where it's going. And step two, regardless of the type of CID you get, whether it asks for, one thing or just testimony from the president of the organization, or it has, 50 requests for documents, information, whether it's a third-party subpoena or you seem to be the target, you need to have a coordinated and strategic response to it, because mishandling a CID, even if you're the third party that just has access to certain information, can have really bad consequences. And so the first thing you want to do is, who needs to be notified per your organization's governing documents and internal policies and procedures. Does the board need to be notified, other stakeholders, et cetera? Second, who should be included in these early strategy sessions about how to respond to the specific CID? Is it outside counsel? Do you have an in-house counsel team? Depending on what is being asked about, is it you need IT experts or an operations people, your membership team? Make sure you identify the relevant subject matter experts that can help make the kind of deliberation more informed. Finally, as Eric mentioned, there's a lot of potential legal consequences. This is the legal consequences if you don't follow process correctly. So does a record hold need to be issued? You don't want to be dealing with accusations of spoliation down the road. Does anyone externally need to be notified? Do you have government contracts that require you to update the government agency that you provide services to if you're the recipient of a CID? Other types of notice requirements based on contracts you have or your governing documents. Again, could be a very serious process. You need to make sure to take all precautionary measures. And then, of course, as Tracy will talk, and all of this is important because this could potentially become a crisis.
Yes, and at this point, too, I think it's important. You can start monitoring. You can start setting up monitoring once you have to start notifying folks who might be outside of your legal team or your outside legal counsel, you run the risk of this sort of leaking out. And so you can set up very quick monitoring processes that will allow you to do social if there's a tweet or someone's posting an employee or someone else, a stakeholder, or if it actually does penetrate the media. But that's sort of a nice way to kind of try to get ahead of what may or may not be coming. These are just sort of general guiding principles. We've talked about them, but they're worth emphasizing. Clear lines of communication, decision-making. Who is that core team? Make sure you get them together quickly. They understand their roles and responsibilities. Who is the decision maker? You can have a core team. You can do it quickly. But if they don't understand the hierarchy of that team, it will not do you any good. Message discipline. This is consistency helps ensure that your message is understood, but it also helps you ensure coordination with this process. So the legal team, the executive team, and others understand and have agreed upon what you are saying and who you are saying it to. We talked about monitoring proportionality. This sort of goes back to the President Trump tweet. There are going to be situations where there might be an instinct to respond. It might not be in your best interest. And so understanding what the consequences are of a response, whether it's an internal response like we were talking about or something more public, is going to be really critical, a critical issue and a judgment that core team needs to be making. Know your audiences. Again, you've got your regulators. You might have built a great rapport with your investigator, but if there are other folks who might be looking outside, sometimes an investigation may start with one entity, but another entity feels some sort of responsibility to jump in and establish its turf around this issue. So understanding who are those core audiences externally and internally.
And one of those audiences is, of course, the potential for private litigation following a governmental investigation, and we see that happen quite a bit. And so as you contemplate all of your responses and what gets disclosed publicly, that's something you really have to keep in mind, because you can't stop it from happening if it's going to happen, but you can put yourself in a better position so that your own public statements aren't later used against you in private litigation.
And even internal. I mean, this goes back to the it's not the crime, it's the cover-up, and not that anyone's covering up, but responses that happen internally or how people respond to these sorts of situations could, as Eric said, become part of that initial investigation or somebody else's investigation. So as you are gathering all of this information, that is where you are going to get your hands around where are your vulnerabilities, where are the areas or the potential landmines that you're going to need to respond to or get out in front of. That gives you time to get ahead of it. I know we're going to get into FOIA in a little bit, but it's also really, really important to make sure that this core team, particularly the lawyers, but eventually the communications professionals, if there are some questionable responses to these investigations, know about those and move on those very quickly.
So step 3, Eric covered a lot of this. Just really quickly, now that you have your response team assembled, the kind of first decision point is your organization going to cooperate? Most, CIDs and subpoenas are not self-executing, meaning that the agency that issued the CID, in order to compel the production of the information, testimony, documents, would have to file a lawsuit in court asking a judge to, in turn, compel the organization to turn over those materials. So we could talk about, debate, the pros and cons of not cooperating, but that is an option. And for some organizations, it's the only option. And that goes to what Eric mentioned up front, where, in some cases, the agency is just clearly overreaching, stepping out of its jurisdiction, doesn't have the authority to issue the subpoena in the first place. We're not going to spend any more time talking about the non-cooperation path. It's fraught with risk, but it's something you really need to consider in certain circumstances. Assuming you are cooperating, you still have a lot of options and things to weigh. And so what I typically, this is the last thing I'll say on this slide, what I typically tell clients to do is map out the worst case scenario. Read the CID request literally. If you're going to turn over all documents relating to membership, what does that look like? Because that's really the only way to understand the potential full burden and scope of responding to the CID, which will prepare you and equip you to try to pare it back down.
I just want to add just one quick point. Anytime you're responding to a request, and Jeff mentioned this earlier, sometimes it's helpful to have a subpoena as opposed to providing information voluntarily. An important issue that always pops up is confidentiality agreements organizations have signed with other organizations or entities. There's typically a provision in there that states that you can provide the information if it's under, if it's pursuant to a request that is compulsory. But there also might be notification requirements pursuant to those contracts. So I would just say that before you ever send any information in, always know where that's at.
And also, when you're negotiating for compulsory disclosure, if you're asking for a subpoena, you can also negotiate the scope of that, and that's very common. And I can't stress this enough. When you're disclosing information, how you disclose it, how you package it up, how you present it, kind of the envelope that you're wrapping it in, whether you're coupling kind of disclosure of some bad things that happen with discussion of all the proactive measures you put in place to make sure that won't happen again, it's so critically important. And that's how we've been able to so successfully, I think, resolve so many IRS audits and other governmental investigations over time. When we had the USAID Inspector General's representative up here on the panel a few months ago, and we had a little back and forth, or she was encouraging all nonprofits to disclose anything they find about any wrongdoing with federal funds to the agency immediately. Whereas I said, it's one thing. Obviously, we're not talking about withholding information that has to be disclosed, but how you present it and package it is so critically important, and pay close attention to that.
So typically, a recipient of a CID will have the opportunity to meet with the investigating staff at the beginning of the process. In some situations, it's actually required to have what's referred to as a meet and confer. This meeting with the investigation staff is so critical for so many reasons. First and foremost, it's your real best opportunity to communicate to the staff why what they've asked for is impossible, really, really, really difficult, going to cost the organization a lot of resources and other expenses. And so the more homework you do up front, the slides that we just covered, with your response team, mapping out what is requested and what that potentially would involve in order to comply literally, the better prepared you will be to present your case to staff as to why what they're seeking is unreasonable. And the most effective way to reduce, narrow, modify the scope and burden of a CID is to make very specific, concrete case for why it's going to be costly and burdensome. I mean, know exactly how many megabytes of data or gigabytes of data, terabytes of data are going to be involved, how many man hours it will take to review. I mean, you need statistics to be prepared to get any type of real good response from them. And this is getting increasingly harder as the agencies in turn increase their IT resources and kind of can know when someone's saying, this is just too burdensome. They actually will press back and say, well, my IT expert does not think it's going to be burdensome to produce 10 million call recordings. I've had this happen. And you have to push back with your IT expert as to why that is the case. So the more prepared you are, the more effective these types of negotiations are. But also, as Jeff was saying, it's typically your first impression with the agency. They decide to send you a subpoena, so they may not have the most favorable impression up front. So it's an opportunity to build credibility, rapport, which should last throughout the entire investigation. And even the most difficult and intractable agencies have been willing to listen and grant some sort of modification. They expect it. So it's, I've had clients that say, well, maybe we'll get brownie points by not pushing back up front. And they absolutely expect it.
Yeah, that's really cool.
Step 5 is actually responding in accordance with the modifications. We can't spend much time on this, but it's a very laborious, distracting, time-consuming process. It's very painful, but it's very important that it's done right, because the ramifications of being sloppy or lazy or not reviewing things before they go out the door are huge. And at the end of the day, the point is to resolve this with the least fallout possible.
And actually, just before we get off that, because there is an opportunity here, and mostly I found this in congressional investigations, to the last point of pros and cons of providing additional information. If there is information that advances your cause in any way, and it might not be directly related, but it positions you, or something that might be tangential is coming out, that this isn't a place to, I found it mostly with Congress when there might be a few allies on a committee that's investigating. Give them some ammunition to help you. And this is where you can do that.
Okay, so the next part of the investigation is going to be where you've gone through the negotiation, you've provided a lot of information to the agency or the committee or whatever's investigated, and then the question is, well, what's next? How do we move this ball forward? Sometimes you'll be in a wait and see place where you've provided a lot of information, it doesn't make sense to engage, and sometimes it will make sense to proactively go forward. At this point, too, it's also very important to make sure you're coordinating with other investigations or litigation that's occurring based upon the same, related to the same issue. Because I've seen this typically when I have a client and I'm representing them in front of a federal or state agency, more often than not, there's a class action involved as well. And that applies when it comes to congressional investigations, too. When I was working up in Congress, I had plaintiffs' attorneys calling me all the time to try to get us to provide information to them. We never did that because that's not what the purpose of the investigation was. But I'm mentioning it to say that there's always something else out there, typically, that would be related that you'd have to be thinking about. And sometimes it makes sense for the class action to be sort of leading how you react to the investigation. And sometimes it makes sense for the investigation to lead, and then the class action follows from there. But it's always very important to be coordinating. And since I'm talking about, I just want to mention that sometimes it actually will work with respect to staff to say, look, we've got this class action happening. We're doing a big document production for them, but it's not happening for another month. Why don't you give us that month so we can be doing this together all at the same time? That's just something to think about, so you're not doing sort of multiple efforts, and attorneys usually understand that. The next point, and this is very important, is the agency-facing advocacy, which basically is telling your story. I don't think this is intuitive, but there's always an opportunity to go in proactively to the staff to explain to them what happened and put together what's called typically a white paper, where it's literally laying out everything the company did, instead of just letting them have their documents and creating their own narrative from documents, because you can certainly do that in a lot of instances. Email can mean a lot of different things depending upon who's reading it. But to tell your story, to explain what happened, with the notion that by explaining this to them, there's a possibility that they'll just drop it. And Jeff's talked about a lot of scenarios where we've had successful representations here at Venable of nonprofits and of companies who are being investigated, where eventually it's just dropped. And part of that process can be the white papers of the presentations in person.
Yeah, creating your own narrative. I like that phrase, because that's really what it's all about. If you just flat out just responded to what they want, and maybe you're holding back certain privilege things, but you're not piecing it all together to, for instance, say, look, we are a very compliant organization. You know, we have great policies and procedures in place, but we had a couple bad actors, and yes, we should have caught it earlier and done something about it, but you know, these are kind of rogue actors, and you shouldn't hold us as an organization culpable for that. That may not become readily apparent from just the straight-out disclosure. So telling your story in that way is so critical.
Absolutely, and that involves the agency, and then also developing a public strategy, a public-facing strategy, which Tracy's been discussing throughout. It's as the investigation nears its end, whether or not it's going to be closed or there's going to be some kind of action, it's very important to be ready for how you're going to be dealing with that with respect to the press as well. And those decisions will end up being driven by where it's headed. And so a government investigation typically resolves itself in 3 or 4 ways. When it's not Congress, but it's actually an agency with enforcement authority, you're going to have a closed investigation, which is always the goal. Sometimes that's impossible, given the facts that are involved and what the agency is looking at. So the next step is typically, and this is, if there's not a closed investigation, more likely than not, you're going to be looking at a negotiated settlement. This may go without saying, but state AGs and the FTC and other agencies, they do not like to go to litigation because that just is it's a drain on their resources. It takes a long time. What they're hoping for is to conduct an investigation, find some kind of wrongdoing, confirm it, and then convince the organization to enter into a negotiated settlement with them. That's what their goal is. They do not want to go to litigation, and typically it's not in the organization's interest to go to litigation either. It's a bad outcome overall, although there are scenarios, I've seen them, where it does make sense for a company to say, or an organization, a nonprofit to say, look, you want to do this, you're just going to have to go sue us. Because we've been talking about it, this has all been it's a legal proceeding here, but it's all been an investigation led by an agency just using their own authority and not going to court and actually filing a lawsuit. And that's always in the background as a possibility.
Yeah, and on this point, too, going back to what motivated the investigation, what was one of the drivers, right? And so if some of the drivers were publicity or coverage about it, they want a win. And so more often than not, they will really push hard for something where they can claim a victory out of this investigation.
Yeah, and that's where the negotiating how it gets publicly disclosed, if it was a non-public, the press release, things like that, what else they can say is very important. And recognize, like, if it goes to litigation, then you lose all control over what gets public or not, because everything is going to be generally out there in the public domain.
Yeah, I should mention, too, I'm not recommending litigation as a strategy, but just that as a possible outcome. We want to include this slide to walk you through what you're looking at when you're trying to get this thing to close, and what different things you need to be thinking about. And most importantly is fact gathering. I can tell you on both sides, it's incredibly important to make sure to understand what the facts are. And when I was on the government side, I had a couple of scenarios where the attorneys representing a couple entities just did not know the facts, and we knew all the facts, and that put their client at a huge disadvantage. And so you've got to know what information you're sending in to the organization, and I mean to the government agency. And maybe they're not doing a thorough job. Maybe they're not looking at everything. Maybe it's just one attorney who's strapped and they're trying to get through 1 million documents and they haven't seen everything. But you have to assume that they have, and you have to be prepared for that. Next is legal research, making sure you understand what the law is, and by doing that, you'll learn, is this just a sort of a cookie cutter run-of-the-mill investigation using authority they use all the time, which will put them in a stronger position? Or is this potentially a scenario where the agency is trying to expand its authority or taking a new approach that they might not have as much justification for? That's very relevant to be thinking about as you're trying to close out an investigation. And then finally, what's the exposure analysis? That's to determine what do these settlements look like in the past when this agency has entered into settlements. What does a consent decree look like? We've been talking a lot about settlements, and we should mention that sometimes settlements will include agencies will require entities to say they're going to do certain things over a period of time, and that can be more costly and more problematic than a monetary settlement. And so it's very important to understand what it is that they're trying to achieve, and then put that all in the analysis on whether or not it makes sense to settle or to move forward further.
And all of that is generally negotiable.
Absolutely, always negotiable.
And knowing, Eric referred to, we see this a lot, an agency kind of pursuing a new legal theory that's maybe untested. If you know that that's the case, and you know that maybe their odds in court are not that great, you really need to understand that we've been able to use that to successfully push the agency into a settlement because they were threatening litigation, but we knew they really didn't want to litigate because they don't want a court going on record saying, no, we don't buy your legal theory.
That's right, because it's better for them to have the question whether or not they have the authority than for a court to just go ahead and tell everybody that they definitely don't. So.
And one thing, we're presenting this linearly, but you want to be doing that work throughout the investigation so you know what leverage you have, if any, and how and when to exercise it. So, up front during negotiations of the scope of the CID, if you know that there are bad facts, it'll affect what you ask for and how much you push on them. Same thing when you're talking about, advocating for closure of the investigation. Credibility is the most important thing. If you know that if we discover through your internal fact analysis that there was a legal violation, then you want to account for that when you present that case for closing. And especially when we're talking about negotiating a settlement. I mean, if you don't know where your risks are, where your strengths are, you're not going to be able to effectively negotiate the best resolution, the best settlement for your organization. So I can't emphasize enough how important that is throughout the process. Eric mentioned at the top of the presentation, we're going to switch gears and present kind of this is also painful and horrible. Is there any, the most important thing is can we prevent an investigation from happening in the first place? And sometimes the answer is just no. There are outside forces that you can't control. But I can tell you, even if you are caught up in something like that, you can definitely minimize the outcome, maximize the outcome, minimize any fallout if you have a good story to tell. And the most important thing is to have an adequate compliance management system at your organization that prevents in the first place and detects legal violations, but also that allows you to tell, give your lawyers something to work with, to tell the story, to put in the white paper that it's a responsible organization, even if there was a slip up or, specific isolated incident that resulted in a violation or potential violation of the law. And having all of these components of a CMS really goes a very long way, especially with certain regulators, to assure them that they don't need to put you under order or they don't need to, have a judgment against you in order to prevent future misconduct.
I was meeting earlier this morning with what's likely going to be a new client who has gone from a kind of a smaller, medium-sized organization to a pretty large organization these days, but really hasn't had the opportunity, the means, or the foresight to really invest in this sort of proactive compliance and education and training and everything else. And it's just a powder keg waiting to happen. But fortunately, they can be proactive and get out in front of these things and work on all of these things from top to bottom, so that if and when an investigation does come, they'll be much better prepared to deal with it.
And one thing I would add is we didn't go through each of these one by one, but vendor management is something that I cannot emphasize enough. Oftentimes, organizations get caught up in something as a result of who they outsource certain functions and work to. You are responsible for your partners and vendors. And so if you're not sufficiently monitoring them, doing due diligence on them, but they're doing things on your behalf in your name, whatever, that could drag you into something that you weren't even prepared for in the first place.
And now that this is over, I know the last thing you want to do is go back and review it in your mind, but this is actually where you can position yourself going forward, right? So it is in your rearview mirror, but likely there were points along the way where you could have done something differently. You learned a lesson, and so it's really important to try to capture that while it's still fresh in your mind and the response team's mind. And then this can become something you use as almost like a template going forward. It can be an evolving response plan, but you have the core elements there. You can put it on a shelf, and next time you have to call Jeff or Alex or Eric, you can pull this off and talk through, okay, here are the steps we know we need to be taking. So it does actually better position you for next time.
All right, I apologize for going over a few minutes, and unfortunately we don't have time for any more questions, but I want to thank our panelists for a terrific presentation today. Thanks to all of you for your great questions, and we look forward to seeing you back here next month. Thank you.